Robert Campbell. Robert Campbell. Gustavo Castillo. Anthony Collard. Anthony Dale Collard. Tammy Crocker. Chasten Esslinger. Noemi Esquivel. Jennifer Gathright. Kelly Gathright. Mandy Jones. Alicia Joyner. Luis Leha. Amber Morvis. James O'Brien. Ashley Olds is appearing via Zoom with the court's permission, and she is present in the Zoom courtroom. Lena Price. Shelby Stanberry. Lane Swanson. Christina Swope. Did I say that right? Jake Wilson. Jennifer Zanella. Jasmine Woods. Bryce Brewer. Christian Berkwin. Joshua Chenault. Dakota Dole. Joseph Hazel. Ginger Malco. Christopher Richardson, CR 23225. We verified that he is in Smith County custody. And I believe that he has been sentenced to Texas Department of Criminal Justice on April 16th of 24. We'll recall that case. Patrick Rowe. Bobby Shaw. Here. Carl Stafford. This is cause number CR 23153. Informed Mr. Moore, who had a family emergency, that he did not have to be here today. We're going to reset the docket call hearing. However, I did instruct Mr. Stafford to be here. Mr. Stafford here. Carl Wayne Stafford. Catwalla Anderson. David Shields. Curtis Wayne Smith, CR 2464, set for arraignment. Waiver of arraignment filed, approved. Pre-trial set June 20th. It's also in CR 2465. Then Shayna Dovey is set for 11. That should be the morning docket. Is there anyone who's present, your name's not been called, and you expect to be on the docket? Yes, I did, and he said he's here. All right, we have any attorneys that are ready? Mr. Hyde, you ready?
Your Honor, we just need to get a plea setting.
Christian Berkman. All right, this is cause numbers CR 23202, CR 24-2, State versus Christian Kane Berkwin for arraignment. Go ahead, Mr. Hyde.
Your Honor, we'll enter a plea of not guilty, but we want to set a date for a plea setting.
All right, is his name spelled correctly in the indictment?
Yes.
Does he understand what he's charged with?
He does. All
right, and court finds that Mr. Berkman has waived the formal requirements of arraignment. Will enter his plea of not guilty into the record for each case. Court will set this matter for pretrial hearing. Mr. Hyde, I have some dates, June 13th or June 18th.
June 13th would be fine.
13th. All right, Mr. Berkman is set for pretrial June 13th at 9 a.m. Mr. Berkman, I want you to check in with the pretrial release officer before you go. I want you to check in with the pretrial release office before you go. Make sure that you're current on your financial obligations. I don't need it. As long as you sign it, he signs it, you put those dates in there. I'll get the white copy, he'll get the yellow copy.
May we be excused, Your Honor?
Yes, you're excused, Mr. Berkman. See pretrial release before
Yes.
you go. There's Mr. West back there. All right, court cause number CR 23-133, CR 23-156, CR 23-157, State versus Jennifer Paulina Zanella. And I believe that we're set on docket call today.
Yes, Judge, we reached an agreement as far as the plea, so we're going to ask that you set it for a plea.
Okay. All right, let's see here. I've got a few dates that you can pick from. I've got something as soon as May 16th, May 28th.
Let's do May 28th, Your Honor.
All right, court sets Ms. Zanella for plea. Is that plea going to be for a probated sentence or
It
for a
is.
time sentence? Probated,
Probation.
and that will be on Tuesday, May 28th at 9 a.m. Here you go.
Thank you, Your Honor.
All right, court call CR 24-10, State versus LaJasmine Marquette Woods. Mr. Allen, we're set for pretrial today.
Yes, sir. I think we're gonna need another pass, Your Honor. The discovery is still not complete.
What are we lacking?
The lab reports.
State?
Your Honor, I was advised by that by Mr. Allen this morning. I will take a look into it and make sure we can get that to him as soon as possible.
So you're saying that lab reports just haven't been provided to you, or there is no lab report?
Well, I'm not sure, but they haven't been provided to me.
All right. Is there anything else, Mr. Woods, I'm sorry, Mr. Allen, that you're lacking discovery that you're aware of?
No, Your Honor.
So we don't need a long reset?
No.
I've got the May 16th or May 28th,
May 28th.
May 28th. All right, court sets Mr. Woods for additional pretrial on May 28th at 9 a.m. Once he signs, gets his notice, he's free to go.
Thank you.
Mr. Brewer, cause number CR 23-203, CR 24-3, State versus Bryce, Andrew Brewer. Mr. Hawkins, I show that we're set for pretrial.
We are, Your Honor. We're negotiating with the state. I believe we'll have an agreement worked out pretty quickly. We just need another pass to be able to work that out with the other co-defendants.
All right, so there's no pretrial motions needing a hearing?
No, Your Honor.
All right, court will set Mr. Brewer for a docket call. Mr. Hawkins, do you want that May 28th or do you need something a little further?
I think May 20th will be,
I think
May 20th, looks like it'd be fine, Judge.
Court sets Mr. Brewer then for docket call May 28th at 9 a.m.
Your Honor, I'm sorry. I do have a conflict that morning. I'll be in a mediation that morning at 9 o'clock.
Okay,
I apologize.
June 13th.
June 13th will work, Your Honor.
All right, Mr. Brewer is set for docket call June 13th,
Is that 9 a.m.?
9 a.m. Yes. Mr. Brewer, have you paid anything towards your pretrial release fees?
Yes, sir. I tried to pay it yesterday and it said I was unable to.
Okay, then I want you to go meet with the pretrial release officer before you leave.
Yes, sir.
And let's get that paid today.
All right.
All right, I'll show that you're delinquent $120.
I paid that in, April. Paid that in April. I paid, me and my mother, we paid 120 and I have screenshots of it and everything we paid.
Go meet with the pretrial release
I'll meet
officer.
with him.
He'll get you squared away.
Thank you, sir.
Your Honor, may I be excused?
Yes, thank you, Mr. Hawkins. Mr. Wheeler, are you ready?
I am.
Good morning, Your Honor. Good morning. This is cause number CR 24-66. The swope is set for arraignment. Go ahead.
Your Honor, on behalf of my client, Christina Swope, I enter my appearance. For the record, Jim Wheeler, and we waive arraignment, enter a plea of not guilty. We have negotiated an agreement, so I'm asking for the court to set us for a plea date.
Okay. The plea at this time is not guilty though, is that correct?
At this time it is, yes, Your
All right, court finds that Ms. Swope has waived the formal requirements of arraignment, enters her plea of not guilty into the record at this time, and sets this matter for plea. Is there a certain amount of time you're looking for, Mr. Wheeler?
No, Your Honor, they've uploaded the discovery into the portal. I'll review it with her. I should be ready by the end of the month.
Okay, you want that May 28th?
Please, Your Honor.
I can give you more if you need more.
I think that's perfectly appropriate.
All right, court sets Ms. Swope for plea on May 28th at 9 a.m. And Ms. Swope, if you haven't signed the conditions of pretrial release yet, then I need you to meet with the pretrial release officer today to do that.
She doesn't know where pretrial release is. Where does
Well,
she go?
he's outside. Mr. West is the pretrial release officer. If she'll just check in out there with him, then we'll bring the paper to her and get it done.
Thank you, Your Honor.
You're welcome.
And do I need to give a copy of?
Yes, she gets the yellow copy and the white copy will stay with the court.
Thank you. Thank you, ma'am. May I be excused?
Yes, thank you, Mr. Wheeler.
Thank you, Your Honor.
Mr. White, you ready?
I believe so, Your Honor.
Who would you like to call first?
David Shields.
Oh. David James Shields, CR 22-363.
Thank you, sir.
All right, Mr. Shields is set for docket call today.
Your Honor, we have come up with an agreement, but we couldn't get the paperwork done for today. We could have another date. I will be in court on May 28th.
What about Thursday, May 16th?
I don't think I have anything at all on that day.
Mr. Shields is set for plea for the court May 16th. Will that be for probated sentence or?
Yes, probate.
All right, that'll be at 9 a.m. All right, once he signs and gets his notice. Yeah. Ready on Catwalla Anderson?
Yes.
Catwalla Anderson, CR 23, 197, 198, and 199. All right, Ms. Anderson is set for docket call.
Your Honor, we, and the state has agreed that we would have, one more, final docket call. Believe that we have this, resolved. There are some situations though concerning probation that my client is wanting me to find out a little more specifics.
All right, court will set Ms. Anderson for a final docket call on Thursday, May 16th. At 9 a.m.
And Your Honor, I believe that is all I have in front of the court.
Thank you, Ms. Wright. Ms. Anderson, I want you to check in with the pretrial release officer, Mr. West, before you leave.
Okay, no problem. Thank you.
You're welcome. Thank you, Mr. White. Mr. Swanson. All right, this is Sanctions Court hearing, cause number CR 21252, State versus Lane Swanson. All right, Mr. Swanson, I see that you've continued to be in compliance with your payments to court collections, to probation. You're doing your community service. It looks like you're kind of back on the right track. How would you report things to be going?
I'm doing pretty good, for the most part, yes, sir.
Any issues?
No, sir.
All right. All right, Mr. Swanson, I told you probably a month ago, 2 months ago, that if I saw a consistent performance from you, that I was going to release you from sanctions court. Today is that day. You're free to go.
Thanks, sir.
So you're back on, you're still on probation, but you're not having to come back here for sanctions court anymore.
Yes, yes, sir. And I did pay off my court fines too.
Oh, excellent. Thank you. Do appreciate that. Well done.
Thanks, sir.
Have a good day.
Yes, sir.
Shelby Stanberry. All right, Ms. Stanberry. We had you in sanctions court for your community service, right? Looks like you've gotten all that done. Where did you do your last 33 hours?
I did 30 at First Monday and then I paid 3 hours to Man Food Bank.
Excellent. Okay. You're going to expire in 8 days.
Yes, sir.
That's good. You looking forward to that?
Sir.
You've got 8 days of probation left. I'm going to release you from sanctions court today, obviously. So I want to commend you on getting that done. I think sanctions court worked for you in that it helped you get everything done in order for you to expire on time. I know you were extended for 1 year, but without sanctions court, it's likely that you would have been revoked and sent to state jail, prison, right?
Sir.
So it looks like sanctions court has definitely done its job for you. And, Sanctions Court's an opportunity, but it's only an opportunity for those who accept it, do something with it, and you did something with it. So congratulations on that. I'm gonna release you from Sanctions Court. And don't screw up in the next 8 days and you're done with probation.
Thank you.
All right, free to go. Mr. and Ms. Gathright, y'all come up together. All right, looks like both of you are in compliance, have been consistently on making your payments, your to probation, to court collections, you're doing your community service as ordered. So the court believes that you're going to be capable of maintaining this on your own without further disruption by Sanctions Court. So I'm going to go ahead and release you from Sanctions Court today, and you're free to go.
All right, thank
All
you,
right,
sir.
just make sure you stay compliant with probation and you won't have to come back through this process.
That we will.
All right, you have a good day.
Thank you.
James O'Brien. All right, Mr. O'Brien, you complied with your payments to probation, to court collections. You've done your community service. I think you're on the right track to being released from Sanctions Court very soon. So I want to see a couple months, more months of this, and then I'm going to tell you the same thing I told the people before you. Okay, so I'm going to have you come back. I want you to do the same things that you've been doing: 65 to probation, 60 to court collections, and 10 hours community service. And I'm gonna bring you back on, let's do Tuesday, well, let's do Thursday, June 13th. Does a Tuesday, Thursday matter to you? I mean, I can put you on, if one's better than the other, I can do that.
Nah,
Doesn't matter?
just either one, it don't matter.
Okay, we'll do Thursday, June 13th.
Can you hear me?
Yes, I can hear you. All right,
Okay.
this is Sanctions Court hearing for Ashley Olds, cause number CR 20-302. Court finds that Ms. Olds has paid her probation fees, her court collections, and everything is in compliance. So Ms. Olds, I'm gonna have you come back on June 13th. And one more successful month, I'm gonna recommend a probation that we remove you from Sanctions Court.
Okay, thank you.
So June 13th, and you can appear via Zoom if you meet the same conditions. If you're paid up on time prior to, then I'm fine with Zoom again.
Okay, thank you so much.
You're welcome. Have a good day.
You too.
Mandy Jones. All right, this is sanctions court hearing. Ms. Jones, you complied with all of your requirements. You paid your probation fees, your court collections. You did your 10 hours. Remind me where you're doing your community service.
I've been doing it at First Monday, but I went to Edgewood this last week, so
Okay. How was it over there?
it's all right. It's slow. I'd rather do it at First Monday.
Staying busy, huh?
Yeah.
Okay. All right. Well, I'm gonna bring you back on June 13th. Same thing, $65 to probation, $55 to court collections, 10 hours community service. As you can tell from the people before you, if you can demonstrate that you can handle these responsibilities without me checking on you every month, then I will release you from sanctions court. So show me that you keep on doing it like this. Give me a few months of consistent performance and I'll let you out of sanctions court. Okay? Amber Morphus. All right, Ms. Morphus, let's see, you complied with your probation payment, you complied with your court collection payment. Came up short, or I'm not sure if you worked any community service.
I did. I actually turned in 30 hours
When did you turn that in?
to the probation because I've been doing it at the rodeo in Grants Lane.
Did you turn it in before
Yes.
last Friday?
Yes, I did.
When did you turn that in?
It was Thursday, I believe, because I had a group with my probation officer for the Tacoma group with Miss Jennifer Lamprey, and I handed it to him, and he made a copy of it.
Okay. All right, we'll check on that. I'm going to reset you to June 13th. And same things, same goal, $65 to probation, $50 to court collections, and 25 hours community service.
Yes, sir.
Okay? You keep on working the 25, 30 hours, you're gonna get it caught up and done pretty quick. Okay? So
Yeah,
it's
I've
work.
already got 25 already for this month. too,
Excellent,
So
excellent, good. Then that means you're already in compliance for the next one.
thank you.
Mr. Esslinger? All right, Mr. Esslinger, I'm gonna release you from sanctions court today, okay? I want you to note, though, that these amounts that we've set for you, you have to pay those monthly if you want to expire on time.
Yes, sir.
So even though I'm releasing you out of sanctions court, you still need to be meeting those same things, $155 to probation and $110 to the clerk. I see that you've done all of your community service. Did you just wrap that up?
Wrapped it up last go around before, after our visit, that first Monday I followed up,
Good.
did
Oh,
all
we
my
talked
hours.
about that, yeah.
Yes, sir.
Excellent, okay. All right, so so you're released today. You're back on just reporting to your probation officer. Just keep in mind, 150 to probation, 110 to the clerk. You need to be hitting that every month so we can get you expired on time.
Yes, sir.
All right, free to go, man. Good job.
Yes, sir. Appreciate it.
Oh, I'm sorry, Chaston. Ms. Burns needs to speak to you before you leave. Sorry, she told me to remind you and I forgot. Noemi Esquivel. All right, let's see here. Last time we said that you had to work 15 hours community service, $90 to probation, $300 to the clerk. We did a 3-day jail buyback. It looks like you complied, you paid your $300 to the clerk. It says that you only paid 40. No, I'm sorry, you paid 90 to probation and then you paid an additional 40. Is that correct? Paid one-
It's supposed to be 120.
Well, this is,
Something.
this was 130, 90 to probation and then
Yeah,
an additional $40. So it said you paid 130.
yeah.
But it says that you came up short on your on your community service. What happened on that?
I don't think so.
It says that you only completed 5 hours.
No,
What'd you do?
no, I've been going to Edgewood.
When did you report your hours?
I've been going every Saturday.
Right, but I'm saying, when did you report them to your probation officer?
I report with her.
With,
I forget her name, Burns.
Ms. Burns?
Mhm.
But when did you turn in your hours?
I just went last Saturday.
So that's the problem. You have to have those done the Friday before. That's how they get reported to me. The deadline is to have all those things done the Friday before your court date. So if you did them on Saturday, it was after the report day. They compile all of this information by the Friday before. But how many hours did
I've
you
been
do?
going 15.
15.
Mhm.
What do you have? You said that you did some hours on April 27th.
I've been going for the past 3 Saturdays to
So-
Edgewood.
So the 13th, the 20th and the 27th.
What, yeah,
And you did 5 hours each day?
yes.
All right, Ms. Escobar, what I'm gonna do is I'm gonna allow you to speak with Ms. Burns in a moment. Y'all can figure that out. I'm gonna go ahead and reset you to June 13th. Looks like you're supposed to expire in January of next year. All right, for you to expire on time and avoid an extension, you have to do a minimum of 30 hours a month, community service,
Okay,
okay? This is if you want to expire in January 25th. You gotta do 30 hours a month. You have to pay $300 to the clerk per month.
Mhm.
You have to pay $175 to probation. This is because you've gotten way behind
okay,
on your fines and fees and your community service. So I'm gonna bring you back on June 13th. And let's do let's do 150 to probation. Let's do 300 to the clerk. So it's very similar to what you did last month. Let's do 30 hours of community service. If you get towards the end of your community service, and you get to the end of your period, community supervision period, and you don't have all of your hours done, we can extend you for that. Okay, we can
Okay.
extend you to give you time to get that done.
okay,
All right, but I want you to go ahead and start making it a priority. Let's try to get it done before the end of the period. Because if you get extended, it's gonna cost you more money.
okay.
That makes sense, because you're gonna have a supervision fee, you know?
Mhm.
So, you're looking at $450 a month until the end of the year,
Okay,
plus those hours. So I know that's a lot, but, if you get your probation fees paid off, you get your clerk fees paid off, and if we do have to extend you, then you would only have a supervision fee. Okay, so let's make that a priority. So let's see if we can get this done. Come back on June 13th.
okay.
All right. Ms. Crocker, Tammy Crocker. Come on up. All right, Ms. Crocker, for your sanctions court, I ordered you to do three things. And I ordered those that if you didn't do them, that there'd be a day in jail for each one. And you complied by paying your probation fee, you complied by paying $80 to restitution. And so the only thing that I don't have you in compliance for is your written plan on how to pay off restitution. Do you have that with you?
Yes, sir. I believe that's how much I owe. I just looked on the page where I make my payments. So I went by that amount.
All right, this looks good. What I want you to do is I want you to sign it.
Yes, sir.
And date it at the top.
Okay.
I want you to print your name, sign your name, and date it at the top.
Yes, sir.
All right, Ms. Crocker, I'm gonna have you come back on June 13th,
Yes, sir.
and I want you to pay your $90 to probation.
Yes, sir.
And I want you to pay $100 to your restitution,
Yes, sir.
okay?
And I'll work on my plan.
Yes, so I was gonna tell you, I say $100 to your restitution, but I want you to follow the plan that you laid out.
Yes,
That's
sir.
what I want you to strive for. If
Yes,
you
sir.
do your plan, you'll take care of my plan,
Yes, sir.
okay?
Yes,
I
sir.
want you to do that. Do you have a copy of this?
No, sir.
All right, we're gonna get a copy for you. I'm gonna have you come over here and
Okay.
they're gonna keep this, but we're gonna give you a copy of it, okay?
Okay.
All right.
I need
See
to
you
sign.
back on June 13th. $90 to probation, $100 to restitution. And thank you for that plan. That's what I was looking for.
Yes, sir. Thank you. Thank you, Judge.
You're welcome. Misty Backus? Yeah, Rachel's gonna cover it. All right, Misty, let's see, you comply with your probation, comply with your court collections, did your weekly counseling, all that looks very good. It looks like you came up a bit shy, 3 hours short on your community service. I think I ordered 24, you did 21.
Yes, sir.
I'm not gonna yell and scream at you for coming up 3 hours short, okay? Just know that for everything you come up short on it, it gets delayed to the next month, and so you don't want that to build up, all right? So, let's come back on June 13th. Let's do same thing, 65 to probation, 115 to court collections, 24 hours community service, and do your weekly counseling, all right? If you can meet that for 3-4 months in a row, then I know that you've got a good handle on it, and I'll let you go. Okay? Anthony Caller. Gustavo Castillo. All right, Mr. Castillo, I ordered you to pay your probation fees, court collection fees, and do 10 hours community service. This report here says you didn't do any of those.
I dropped the ball. I got it all done this week and paid this week. That's the Friday after, so.
Did you do your 10 hours community service?
Yes, sir. I did them here at the courthouse.
Oh, that's right. I saw you the other day.
Yes, sir.
All right, so I want you to come back on June 13th. So this time, so that you don't drop the ball, we're gonna add a day in jail for each one of those that you don't do on time.
Yes, sir.
Make sense? So you gotta pay $65 to probation, $50 to court collections, 10 hours community service. For each one of those that you don't do on time will be 1 day in jail.
Yes, sir.
So don't wait till the last minute and try to get them all done, okay? You have any questions about that?
No, sir.
All right, we're gonna give you a notice to sign. Once you sign that, you're free to go.
Thank you.
Mr. Leha? All right, Mr. Leha, you were ordered to pay $220 to probation fees to work 30 hours community service. It says that you did turn in 30 hours, but you did it after the deadline. You did it on Monday of this week rather than having it turned in by Friday of last week. Why did you do that?
So I did start a new job and it's been difficult to like get to the community service hours, and I just worked through the weekend and stuff to be able to do those hours. And I turned them in on Monday and then I got paid Wednesday, so that's why I did the payment on Wednesday as well.
Did you pay on Wednesday?
Yeah, I paid the 220 as well.
Pay the 220?
Sir.
All right, I'm gonna bring you back on June 13th. We have to do 220 to probation. And June 13th is Thursday, so you have to have everything done by, you have to have everything turned in by noon on June 7th, okay?
Okay.
So by June 7th at noon, you have to have your 220 to probation, and you gotta have your 30 hours community service.
How am I gonna do the 220 if do I have to send a money order because I'm only delinquent $60?
This is your Dylan, let's see, well, I guess they did calculate that, so we'll do $60. $60 and 30 hours community service
Yes, sir.
by June 7th at noon. And if you don't meet that deadline, it'll be 1 day in jail.
Yes, sir.
Okay, any questions about that?
No, sir.
Enterprise? All right, Ms. Price, it says that you failed to pay your $70 to probation, you failed to pay your $65 to court collections, and you worked 8 of your 10 hours. Is that right?
It's right here, sir.
When did you pay those?
Last week,
When last week?
I think it was like
Does it say it on
Thursday,
there?
Thursday, it's the,
Is there a date on it?
yes, sir.
What does it say?
Um. I can't find the date on the money order. I can't see the date on the money orders.
You say you turned them in
I want to say probably about Wednesday or Thursday last week.
24th or 25th?
Yes, sir. I mailed them off.
And I didn't look at those. What was the total? 135? 70 and 65? Is that right?
It was 70 and 65.
And then you got 8 hours of your 10 hours done. Is that correct?
I did 2 hours, 8 hours of community service. I did it not yesterday, but the day before yesterday, and I did one last week of 8 hours.
So you're only getting credit for what you did last week that you turned in. What you did this week is after the deadline. You understand that? Everything has to be turned in the Friday before you come to court.
Friday.
That would have been, everything should have been turned in by April 26th. So that's why it's not showing credit on it, all right? So I'm gonna bring you back on June 13th. And you have to pay $70 to probation, and that's how much you have to pay every month in order to expire in May of 2026, along with $65 to your court collections, 10 hours community service.
Okay.
Have all those done on June 13th, and I'm gonna put three-day jail buyback for each one of those. For every one that you do, you know the drill. For every one you do, you don't have to do a day in jail.
Alrighty.
All right. So if you're coming back on June 13th, then your deadline, and I want you to write this on here, Mr. Abraham. Your deadline to have all that turned in is Friday, June 7th at noon. You get all that done, those 3 things done by Friday, June 7th by noon, turned in. Don't wait till noon, because they're gonna close it. Get that turned in. Best thing you could do is have it turned in on Thursday before.
Okay, I'll do that, sir. Thank you, sir. You have a good day.
You're welcome. You have a good day as well. She bought it on the 11th. Wilson? All right, this is Sanctions Court, CR 2277, State versus Jake Wilson. All right, let's see, Mr. Wilson, I ordered you to do $60 for probation, 50 to court collections, 10 hours community service. My report says you did turn in your hours with community service. It says that you didn't pay your probation or your court collections. Is that right or wrong?
I didn't do it on time.
You didn't do it on time? When did you do it? Did
I
you
did it
pay
Monday.
Did you pay it though?
Yes, sir.
When did you?
I
pay
was
it?
just like, I paid it Monday.
Paid in full?
Yes, sir.
Where'd you do your community service?
Rodeo,
Grand Saline Rodeo?
Canton. 4 days.
All right, Mr. Wilson, I'll have you come back on June 13th. Let's do $60 to probation, $50 to court collections, 10 hours community service. Cause I gotta make sure that you hit your deadlines. I'm gonna tie 3 days in jail, a day in jail for each one that's late.
All right.
Okay, so June 13th is a Thursday. You gotta have everything turned in by noon on Friday, June 7th.
Sure.
Okay, so get those things done and you'll be one of the first ones out the door on that day.
All right. Thank you.
All right. All right, court's gonna stand in recess for 15 minutes. Mr. Manning, are you ready on any of your clients?
Judge, ready to know.
Who would you like to call first?
Judge, can you get Mr. Hazel?
Mr. Hazel? This is cause number CR 19-233, State versus Joseph Ryan Hazel for docket call.
Judge, we received an offer just this week. I've conveyed that to my client. He would like an opportunity to review that and discuss the pros and cons of that offer.
All right, any objection to resetting for additional docket call?
No objection, Your Honor.
All right, Mr. Manning, how about Thursday, May 16th, 2 weeks?
Judge, as it is an offer for time and time alone, I'd like a little bit of chance for my client to, if that's what we end up taking, give a chance to.
Well, I mean, it'd be docket call. He could accept it on that day and we could set it for a plea. I wouldn't expect him to take it that day.
Okay.
So it gives him 2 weeks to consider it.
Okay, that's fine.
All right, court sets Mr. Hazel then for docket call, final docket call on Thursday, May 16th at 9 a.m. If he wants to take it on that day, then we can arrange for that. But if not, I'll just be expecting an announcement.
Yes, Judge. Hey, Mr. Hazel, be excused.
Free to go.
Thank you, Judge. Next, ready on Ms. Malco.
Ginger Malco, CR 2360. Goodness.
Judge, same announcement we had last time. We're waiting on the co-defendant's case, and we request a reset on our docket call.
The objection from the state.
No, Your Honor, I can add a little bit of context. Co-defendant set on 5/28, spoke with the defense attorney in that case, and he's expecting no less than 30 days until he can resolve what he's looking at. He's expecting it to be more than 30 days, but
Are we set in the co-defendant's case for final docket call or anything?
Your Honor, I believe it might be the first docket call.
Who's the co-defendant?
Mr. Nowak.
Joshua Noat?
Yes, sir.
Yeah, you're right. First docket call. Okay. All right, so. All right, we'll reset Ms. Malco to Thursday, July 11th. Do you have any scheduling issues then, Mr. Manning?
If I may just check one.
So.
Judge, I believe that'll work.
All right, Ms. Malco is set for 9 a.m. Thursday, July 11th.
And Ms. Malco be excused.
Yeah, it's ready to go.
Next, ready on Mr. Rowe.
Patrick Ray Rowe, CR 23-116. And also CR 23-117. Good, Mr. Manning.
Judge, we had reset this case a couple times for discovery. I had begun review of discovery and got about 1/3 of the way through. I spent over 7 hours last week in the DA's office reviewing discovery. But unfortunately, I was unable to get to Mr. Rowe's case as I was reviewing cases that were for clients that were in jail. I'd asked, since Mr. Rowe is out of jail, would be given some additional time for me to complete the discovery on his case. Like I said, I think I'm about 1/3 of the way through his material, and I've spent at least 4 hours on his case reviewing that discovery so far.
You available June 13th?
Yes, Judge.
The objection to the pretrial being reset to June 13th.
No, Your Honor, I know the discovery is quite voluminous.
All right, court sets Mr. Rowe for additional pretrial hearing Thursday, June 13th at 9 a.m.
Thank you, Judge.
each case.
May Mr. Rowe be excused?
Yes, free to go.
Thank you, Judge. Next, I was ready on Bobby Shaw. My understanding is that he was taken into custody while I was not present in the courtroom.
Correct. We'll just move him to the afternoon docket.
Okay, Judge, I would ask that since he was present, that a NISI not be
Of course.
granted on his case.
Yeah, no nice. We're gonna hear him today at the docket, so.
Next, Judge, ready on plea for Mr. Dole.
Coda Dole. This is cause numbers 2021-539 and CR 23-147. All right, Mr. Dole, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Sir, you lower your hand. Is your name Dakota Blake Dole? Yes, sir. And Mr. Dole, are you a United States citizen who reads, writes, and speaks English? Sir. Have you ever been diagnosed with any type of mental condition? Sir. In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's legal work that he's done for you? Sir. You feel like you've had enough time to discuss the case with him and have all of your legal questions answered? Yes, sir. Is there anything about the paperwork that's part of your plea agreement that you've read over and signed today that you do not understand? No, sir. Mr. Manning, do you believe Mr. Dole to be competent to enter into this plea agreement? And if so, have you explained to him his rights concerning the case and that he is entering into this intentionally, knowingly, and voluntarily?
Judge, we haven't been able to discuss his case. He is competent. We have discussed the consequences of his case, both with the finding that the courts will make, but also the collateral consequences that will be associated with this. And I believe he's entering into this plea intentionally, knowingly, and voluntarily.
All right, it looks like Mr. Dole appeared before the court in cause number 2021-539 back on March 7th of 2022, in which he pled guilty to the Class A misdemeanor offense of assault causes bodily injury of a family member. The court heard the evidence, followed the plea agreement reached between the defendant and the state, followed the state's recommendation, deferred a finding of guilt, and placed Mr. Dole on community supervision for a period of 1 year. And then Mr. Dole's community supervision was then extended for an additional 1 month period ending on April 6th of 2023. It was during that period that the state of Texas filed this motion to adjudicate on March 30th of 2023. And in that motion alleged violations in 3 separate counts. It appears that the plea agreement today is that Mr. Dole would be pleading to counts 2 and 3 in that motion. And that the state would be recommending upon that plea of true that Mr. Dole's guilt be adjudicated, that his supervision be revoked, that his punishment be assessed at 3 days confinement in the county jail, that he be ordered to pay the balance of his financial obligations, which I think consists of a $50 reimbursement fee, and that the state would, or the state has tendered a motion to dismiss cause number CR 23-147, which is an indicted offense of aggravated assault with a deadly weapon. Is that your understanding, Mr. Manning?
It is, Judge, and I also have included the court cost sheet in the plea paperwork that is from the county clerk's office that shows that he has paid all his financial obligations with the exception of the newly assessed $50 fee.
Very well, thank you. And Mr. Dole, is that your understanding of the plea agreement? Yes, sir. All right, Mr. Manning, does your client waive the formal reading of the state's motion to adjudicate?
He does.
All right, Mr. Dole, at this time, I would ask you, how do you plead to counts 2 and 3 in that motion? Are those counts true or not true? True. and you're telling me that the allegations alleged therein are true because in fact they are true. You're not just telling me those are true so that you can resolve your case. So, okay. Court will accept the defendant's plea of true. Mr. Manning, any objection to the admission of the defendant's waiver of rights in plea of true?
No objection to state's one.
All right, that is admitted in the court. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Bench rest and close.
All right, then based on the evidence presented to the court finds that Dakota Dole has violated the terms and conditions of his community supervision. Court follows the plea agreement today and revokes his community supervision, adjudicates his guilt, convicts him of the Class A misdemeanor assault causes bodily injury of a family member, assesses punishment at 3 days confinement in the county jail. The court orders him to pay the balance of any unpaid financial obligations previously ordered. Court finds that the state has agreed to abandon count 1 on the state's motion to adjudicate. And the court does award Mr. Dole 3 days credit towards his incarceration in this matter. For the state is also granting the state's motion to dismiss in CR 23-147. All right, Mr. Dole, I'm gonna have you come forward to be fingerprinted. Pause. Ready.
Judge, ready on my last case, Mr. Chenault.
This is cause number CR 23-8, State of Texas versus Joshua Lee Chenault. All right, Mr. Chenault, if you raise your right hand, I'm gonna place you on the oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Lower your hand. Your name is Joshua Lee Chenault, is that correct?
Yes.
And Mr. Chenault, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's legal work?
Yes.
Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Sir.
Is there anything about your plea agreement, this paperwork that you've read over and signed today that you do not understand?
No.
Mr. Manning, do you believe Mr. Chenault to be competent?
I do, Judge, and I must say, throughout the corporate star representation, I don't know if I could always have answered that, but he is here today, the best I've seen him. He's mentally clear. He's able to interact and respond to the questions that I've had for him, and the questions he's had for me have been intelligent and knowing about his case.
All right, and Mr. Chenault, you are charged by indictment with a second-degree felony offense of burglary of a habitation that does carry a range of punishment. If you were to be convicted and sentenced, the sentence must be between the minimum 2 years to a maximum 20 years confinement in prison with a fine, if imposed, not to exceed $10,000. I see the plea agreement in your case is that upon your plea of guilt to this offense, the state's recommending that your guilt be deferred. That means that the court not convict you today, but rather defer a finding on that issue. And that they're recommending that you be placed on community supervision for 6 years, a fine of $1,000, placement on the intensive supervision program as a condition of your community supervision, You would also have court costs of $290 and reimbursement fees of $625. Is that your understanding as well, Mr. Chanel?
Sir.
All right, understanding the range of punishment in the plea agreement, Mr. Chanel, how do you plead to burglary of a habitation?
No contest.
Is that part of the agreement?
Judge, he spoke to me just before we were about to play and asked if he could plead no contest. I didn't have a chance to talk to the state about that. I've explained to my clients the results of the no contest and a guilty plea are the same in this court. However, he is asking to plead no contest.
Is there any objection from the state to the court accepting a no contest plea?
Your Honor, the agreement was that he would plead guilty, so the state would object.
Y'all want to talk?
If I can just.
Yes.
We may step out for just a second.
Yes, absolutely.
There it is. There it is. He's gonna interrupt. I don't know. He's meeting, man. It's pretty enough. Thank you. Right, what's that?
Go ahead, I can cover it. I can cover it, see if we can catch him.
All right, Mr. Manning.
Yes, Judge. We had an opportunity to discuss the state review the state's evidence as we had previously reviewed it. We were reminded of the difference between factual innocence and guilt and the legal standards for those. And I believe that Mr. Chenault is ready to proceed on this plea.
Is there a question about actual innocence and sufficient legal guilt? I mean, it seems to me that if he's pleading no contest, he may in effect be saying he's not guilty.
Judge, there were discrepancies as to the complaining witnesses' reports and statements that have since been, the complaining witnesses have sought to drop the case and withdraw from proceeding from the case. And if that were the only evidence, then I would not recommend my client be taking this plea. However, there's additional evidence that we have discussed and gone over. And that's what we were discussing in the hallway, is that additional evidence beyond the complaining witnesses. They are the ones that requested he be given a chance on probation. And then in the interim period of time, they've made further requests to drop the case completely and totally. But the DA's office has not chosen fit to do so.
Counsel, can you approach? You and your client ready, Mr. Manning?
Yes, Judge.
All right, so, you've had adequate time to speak with Mr. Chenault privately, regarding his, intended plea in this case, and at this time, do you feel like you've had enough time to do that, Mr. Manning?
Yes, Judge. If we can though, if we can give just so it's on the record, have the admonishment regarding the difference between a no contest and a guilty plea.
All right, Mr. Chenault, I understand that previously you entered a plea of no contest. The court then inquired as to whether or not that was part of the plea agreement. And the state indicated, as you're aware, that that was not part of their agreement to allow you to enter a no contest plea. Legally speaking, a no contest plea in a criminal case, if accepted by the court, if the court reviews the evidence and finds that there's sufficient evidence to convict you of the offense alleged, then the court's acceptance of a no contest plea would have the same legal ramifications as a guilty plea. Usually no contest pleas are utilized in situations wherein either the defendant does not want to oppose or challenge the legal evidence being brought against them in a charging instrument like an indictment, or in situations to where an individual has been charged with a criminal offense and also sued with a civil offense, wherein a no contest plea cannot be used as any indicia or any kind of indication that the person is legally responsible in a civil case. And I understand that there's no civil case in this matter. So at this time, the court could accept a no contest plea, and it would have the same legal effect as finding you guilty based on a guilty plea. They would have the same legal significance. The issue here today is that the state's not willing to go forward with your plea agreement unless you plead guilty. So you understand that?
Yes, sir.
So at this time, you have that opportunity to decide whether you want to plead guilty and accept the plea agreement they're offering, or you don't want to accept that and we move forward with either a bench trial or a jury trial. You understand the difference in your decision about that?
Sure.
Okay, so you've had time to speak with your attorney, Mr. Manning, about a no contest plea, a guilty plea, about the evidence in the case. Is that correct?
Sure.
You feel satisfied that you've had enough time to do that?
Yes, sir.
Okay, so I'm going to ask you at this time then, how do you plead to burglary of a habitation?
Guilty.
And Mr. Chenault, are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
And Mr. Chenault, has anybody threatened, forced, or pressured you to plead guilty?
No.
Okay, you hesitated a little bit, so I've got to inquire about that.
Well, I mean, heck, you just, yeah, I mean, y'all pressure me into guilty, right?
Okay, so you
Obvious, right?
Judge, at this time, we'll withdraw the plea and we'll just set him on the trial docket.
okay, all right, court is going, okay. Court finds that Mr. Chenault indicated to the court that he was going to plead guilty and accept a plea agreement today. And when admonished about the difference between a no contest plea and a guilty plea, he felt like that legal admonishment and the state's disagreement with a no contest plea was a legal pressure upon him. So the court's going to protect his rights today, and the court is not going to accept the plea agreement. And the court will set Mr. Chenault for jury selection beginning. And Mr. Manning, you've had discussions with Mr. Chenault regarding the court's policy on accepting plea agreements after a final docket call,
Yes, Judge.
final announcement.
And actually, I believe we made it to the top 10. If we can, get a special setting on this one, just so we can lock it in and get Mr. Chenault's day in court as soon as possible.
Yeah, I'm not going to give him a special setting, but I'm going to allow him to remain in the top 10. I won't remove him out of there. That means he'll get a trial faster than anyone else on the bottom of the list. So, was Mr. Chenault already set for Monday, May 6th?
I don't believe so, Judge. We had requested he be removed for a plea today.
Okay, so what we'll do is we'll place Mr. Chenault back in the court's top 10 for trial on Monday, June 3rd. I'm sorry, Mr. Manning, let's change that. We'll put him in the top 10 beginning Monday, May 20th.
Judge, may he be excused?
Yes, so Mr. Chenault, we'll see you back on May 20th at 8:30 for jury selection.
All right, thank you.
Mr. Manning, we do have one more we need to call just for a matter of record keeping. This is cause number CR 23-225 State versus Christopher Michael Richardson. Mr. Richardson, as stated before, is verified in custody in Smith County. Did receive a 6-year TDC sentence on April 16th of 24. So I need to know if either party is going to be requesting a bench warrant for Mr. Richardson.
Judge, I don't know what the offer is in the case. I don't know if that's something you'd be interested in taking. Furthermore, because it's been Smith County the entirety of my representation, I've had an opportunity to discuss his case. If we'd like to, if the court would like to issue a bench warrant, I can over here, we talk to him. My concern is if we bench him over here, and he's unwilling, then we'll be housing him for him sitting here.
Mr. Hernandez, do you know if the system has an offer that's been made on Mr. Richardson's case at all?
I don't know, Your Honor. I would be requesting the bench warrant.
So Mr. Richardson, he's never been arraigned by the court either, because you said he's been in custody in Smith County.
That's correct, Judge.
All right, let's reset Mr. Richardson for bench warrant status. I'm gonna give you all time to look at the case together, determine if any offers are gonna be made prior to the time we bring him over.
Okay, thank you, Judge.
Let's, we'll set him for that June 13th. And Mr. Hernandez, if in the meantime, when you review that and after you make an offer, if you're gonna make one to Mr. Manning, if you'll just contact Ms. Tabraham, send her an email, let her know that you want a bench warrant, and then we'll try to get him back before June 13th.
And Judge, I put him on for 1:30 and see what will be the best.
Yes, sir.
Will do, Your Honor. Thank you.
All right, Mr. Manning, does that complete your morning docket with the exception of Mr. Shaw?
Yes, Judge. May I be excused?
Yes, you're excused. We'll see you this afternoon.
Thank you, Judge.
Did you? Yeah. All right, so for the record on CR 23-153, Carl Wayne Stafford, Mr. Moore is the attorney. Mr. Moore had a family emergency, contacted, I believe, the DA's office, who contacted the court. Court's gonna reset Mr. Stafford for plea on May 16th. That's what was indicated to the court, so that's what we're gonna set it for. Court's not gonna require Mr. Stafford to appear today. We'll see him here in a couple of weeks. Yeah, so. That's most of the stuff. All right, court's going to stand in recess for a few minutes to allow Mr. White some time to speak with Ms. Doby regarding some of the revised paperwork. So we'll stand in recess for 10 minutes. All right, Corey calls number CR 22-130 and 131, State of Texas versus Shayna Sapien Dobie. Ms. Dobie, where you're sitting, if you'll just raise your right hand, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Hey, come over here. Go move that one. All right. Ms. Dobie, are you a United States citizen who reads, writes, and speaks English?
Yes,
Have you ever been diagnosed with any type of mental condition?
yes.
Can you tell me about that?
I've just depression, bipolar personality disorder.
And are you currently on medication for any of those?
Yes, sir.
Have you been under the care of a doctor for those?
Yes,
Do you feel like today you have a rational understanding of what's going on despite those conditions?
yes,
In this case, you're represented by your attorney, Mr. Nolan White. Mr. White was appointed by the court to represent you after your previously retained attorney, Mr. Mark Fratter, asked the court to be able to withdraw from your case. You recall that hearing?
yes, sir.
Court appointed Mr. White since that day. And are you pleased with Mr. White's representation of you?
Yes, sir.
Do you feel like you've had enough time, Ms. Dobie, to speak with Mr. White about this charge that's been brought against you to the point where you understand all of your legal rights
Yes,
and you understand all of the allegations against you
yes,
and you understand the paperwork that you've read over and signed today?
yes, I do.
Is there anything that you're unclear about?
No,
You sure?
yeah,
Okay. Mr. White, do you believe Ms. Dobie to be competent?
Your Honor, I've spent quite a bit of time with Ms. Dobie. I don't have no concerns about her mental health and well-being. Believe that everything she's executed here has been done knowingly, intelligently, voluntarily. I do believe she's mentally competent.
Thank you, Mr. White. All right, Ms. Dobie, you were originally charged with the offense of capital murder and also abandoning or endangering a child. I see that the plea agreement in your case is that in CR 22-130, you would be pleading to a lesser included offense of manslaughter, which is a second degree felony and carries a range of punishment of not less than 2 years or more than 20 years in prison, and also carries a fine which cannot exceed $10,000. As part of this plea agreement, it appears that you would be pleading guilty to that manslaughter charge in exchange for the state's recommendation to the court that your punishment be assessed at 15 years confinement in prison, along with court costs of $290 and reimbursement fees of $40. You would receive 588 days credit towards your sentence for the time that you've already spent in jail on this case. And I believe the state is also moving to dismiss the abandoning or endangering a child case as part of this plea agreement. And the state is also rejecting a case of aggravated kidnapping with a deadly weapon. Ms. Dobie, is that your understanding of the plea agreement?
yes, sir.
All right, understanding the plea agreement, understanding the range of punishment. At this time, I ask you, how do you plead to the second degree felony offense of manslaughter?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes,
Has anyone threatened, forced, or pressured you to plead guilty?
no,
Court will accept the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
Your Honor, we have no objection.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that family is here for allocution.
And the family of the victim is supportive of this plea?
Your Honor, if I could have just one moment. Yes, Your Honor.
All right. Anything further from the defense?
Very quickly, Your Honor, as the court previously noted, I'm court appointed on this. The court had allowed me to bill an hourly rate as per the court policy. However, I did not start billing the hourly rate until February. I can't remember exactly when the court gave permission to do so. I think it was before then, but we know that my time is not an accurate collection all the time I spend. I did spend quite a bit of time that, I did not feel that I could accurately swear to, so I did not include any of that, in my, motion for attorney's fees. But I want the court to know for the record that there was more time spent on this case than what was actually.
Thank you, Mr. White. And the court has considered the motion for the payment of court-appointed attorney fees. And the court has approved the same. All right, the court's going to review the stipulation of evidence. All right, the court, having reviewed the stipulation of evidence, finds that there is enough evidence to convict Ms. Doby of this offense. The court will follow the plea agreement as recommended by the state of Texas through the DA's office. Court hereby convicts Shayna Sapien Doby of manslaughter, a second-degree felony, assesses her punishment at 15 years confinement in the Texas Department of Criminal Justice Institutional Division, orders her to pay a $290 court cost and $40 reimbursement fees. The court also awards Ms. Doby 588 days credit towards her sentence for the time that she has already spent in jail on this cause. Ms. Doby, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted, and then after which you'll return to the table. Actually, just stay there. If you have more chance, I'll come to you. All right, Mr. Hartwell, you will have your, I think this name for allocution. We'll do that at this time.
Yes, Your Honor.
This time, the court's going to direct the court reporter not to record the allocution of the victim. What's your statements? Good.
I guess. Thank you.
May proceed when you're ready.
The purpose of this statement is to describe the best the family can the impact that you've had as a direct result of your crime. In helping Ryan, you taking Leslie to your house, his house, and consequently her death. You took away a daughter, a sister, a mother of 4, and a grandmother, and an aunt. We will never see her again. Her grandchildren won't ever get held by their Mimi again. They will miss having tea parties, riding horses, singing and dancing with her, going to McDonald's and going to the park and having fun with the family. You have caused us pain and hurt and loss that there's no comparison. As a mother, I will miss her every day, remembering all the family times we've had and watching her grow and become a woman. As a matter of fact, she would have been 50 years old less than 30 days from the time that this happened. We did not get the chance to celebrate her 50th birthday. The impact you have had has been great. Leslie never forgot Mother's Day. She never forgot my birthday. Sorry. She will never be able to tell us she loves us. She'll never be able to hug her babies again. She loved her grandbabies and she loved her family very much. You took all that away from us. You are a mother. I hope you never have to feel what we have felt because of your actions. And I hope you never, ever forget it till the day you die.
Any further allocutions, Mr. Harwell?
No, Your Honor.
All right. All right, Ms. Dovey, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Go ahead and take Ms. Dovey now. That does conclude the court's morning criminal docket. We'll stand on recess until 1:30.